Hello, fellow toolboxers. Welcome to episode number 321 of Federal Court Update. Kevin Gregg, probably the most important one with the recent Supreme Court decision. So we're going to get into that. I want to thank all listeners. Everyone I met in Chicago is really good. I want to give a special thank you to Park Evaluations, obviously one of the service providers we have in the immigration field, and they're very kind. I met him at the Improv Comedy Jam that our great friend Roman Zachenko did, and I sat at their table. Their team is wonderful at Park Evaluation, so I appreciate them. And also appreciate e-immigration by Serenade. They've been a regular sponsor and one of the main sponsors at AILA. They've been so gracious with their software and the updates and just working with us. And we've seen just what great work they do. And a lot of happy customers are really loving it. So if you're interested, you could always do a sales call with them. It's not really a sales call. It's a walkthrough with their software to see how it is and learn more about it. So just reach out to them, Serenade with the C. They've been around, so if you put it into Google, you'll find it for sure. A great team that works there, very helpful, very on top of it, and we're really happy to work with them. So I've said all that. We also have a course on marriage immigration. If you want interest in that, I forget to plug it, but it's the best course out there. I'll do marriage immigration. But let's get to what we're here for. Kevin Gregg, one of the partners at the Kurzban Tetzelian Pratt firm. I was telling one of your partners I spoke with, Carl Reich, that I'm going to interview Pratt. What gentleman's first name? I know Pratt. I don't know for last name. But
you should remember. It's you.
Is John Pratt? Oh, yeah, John Pratt. You're right, John Pratt. So I think there's one or two more partners that are also I'm best buddies there on the firm at this point.
Right. No, you've got everyone except Eddie, actually. I think you've hit everybody. So that's well, yeah, I mean, not Marvin. Jed, the managing partner, but he's medical malpractice. So if you're interested, you could.
A little off, our topics, but let's kind of jump into it because it's like breaking news. What's happening in immigration space? You take the lead as always.
Well, I'm happy to. Well, we can talk about the Supreme Court cases. We should talk about the Supreme Court cases, even though they're losses for the non-citizens. But at the end of this, I want to turn back to a non-citizen friendly one. So nice. We're going to end then with the non-citizen friendly in a really big decision that's also destined for the Supreme Court eventually. But, besides the Wilkinson decision, which was issued, and I'm sorry, I'm getting over a cold over here, so maybe I'm not as energetic as usual. But besides for the Wilkinson decision earlier this year, which held essentially that mixed questions of law and fact in the cancellation of removal context can still be reviewed by the circuits, a very wonky decision. And quite frankly, it only benefits a non-citizen, right? If they've lost twice at the IJ and then the BIA level. So like nobody wants to be in Wilkinson territory. Other than Wilkinson, it was just losses across the board for non-citizens this term, and America generally, with a lot of the decisions issued, depending on what your view of the law is.
I guess say that. I mean, so Chevron deference it affects all law, but immigration is always a part of it.
Let's talk Loper Bright. We'll talk Loper Bright, Campos Chavez, and Munoz. Well, I mean, so starting with Loper Bright, it's a lot of people are out there talking about this in the immigration space. I'm just put my voice as one of them. I talked about it on my podcast that aired yesterday for the last week episodes. Everybody's talking. There is joy, right? In the immigration space, it means for now that the circuits and federal district court judges owe no deference to, or maybe Skidmore deference, which is virtually no deference, to precedential decisions out of the Board of Immigration Appeals and the AAO when it comes to district court. Yeah. But, with district court, Patel and the like has already cut off a lot of lawsuits. Don't get me wrong. Like, I'm not sure, but no, it's to be celebrated. But of course, it cuts both ways. Like when there are non-citizen favorable cases out of the BIA or the AAO or the like, those aren't owed deference either. Matter of Richmond comes to mind, the false claim to citizenship BIA decision. There are many. Matter of Richmond had already been chipped away at by the 11th Circuit. Maybe it'll be vacated by others because they don't need to defer to it anymore. But on the whole, for the last 20 years, I think most of the more than not, the decisions coming out of the BIA were non-citizen adverse. Those are owed no deference now. So I guess the BIA is publishing advisory opinions for the circuits.
Mm-hmm.
That's probably a good thing. I'm not sure. Already the 11th Circuit had been coming out with some precedent before Loper Bright, knowing Loper Bright was coming, that was flirting with like there's special deference in the immigration context because there's this statute that gives the attorney general unencumbered discretion. I can only imagine that kind of case law is going to be published by some of the circuits, and the Supreme Court will probably get an agency deference immigration case in the coming years, and we'll
Yeah.
get more guidance, and maybe there will be a special deference.
Yeah.
The whole thing just argues for why the immigration courts need to be taken out of Article 1 and stop having the Attorney General and the BIA,
Big time.
have political connections and make it an Article 1 court. And let's really do this thing. Now, they're still not owed deference. It's still an agency. And so what we're really going to get now is a lot of circuit by circuit adjudication of BIA case law.
Yeah, I mean, it's going to be in all. I mean, it's kind of a reset of American law essentially at this point. Since I was born, it's been this one way. It's a whole new field now. It's a whole new ball.
Chevron's the most cited, in my understanding. It's the most cited Supreme Court decision of all time. I mean, if stare decisis doesn't mean something for Chevron, it means it doesn't mean anything, which they've already made clear with Roe and with now Chevron and with the Voting Rights Act cases and a lot of decisions over the last couple of years. As much as we celebrate with immigration, I'm not celebrating as a human who needs to live in this world. Our lives are governed by agencies. It does seem that big business is the biggest winner by killing the ability of agencies to regulate and subjects everything they do, be it the EPA or other entities, to federal court litigation. There aren't many people who can afford federal court litigation, but big business can when they don't like regulations.
Mm-hmm.
That is what Chevron means. That makes it more difficult for the U.S. government, the most powerful country in the world, to help fight the climate crisis, to help prevent another financial crisis, for regulating pills that help women's reproductive rights, for making sure the food we eat is safe. I mean, all of those things are now subject to expensive litigation by well-funded entities that might disincentivize regulations from being implemented in the first place. The Supreme Court seems to be creating a framework that expects the legislature to say everything they want to happen in every little area. It's impossible, even with a legislature that was working. The regulations are 1 million pages long, but also the Supreme Court knows that Congress doesn't pass anything these days. So in effect, it gives us no regulations. And I wasn't around in the 70s, but it did seem, with rivers on fire and people dying and the ozone layer being killed by pollutants, that regulation can often be good. It's scary. It's scary stuff. But that's what the end of Chevron means. In the immigration context, maybe it's a little good. We'll see.
Yeah, we'll see. Because as you said, they might just come around and say, "We'll make it a Chevron exception for immigration." That's what's probably going to happen.
Yeah.
And then, where's the
administrative law professor smarter than I and you will be speaking soon. I'm going to be doing something with the ABA Commission on Immigration, I think. It's very interesting stuff. But for now, it's a pretty much a good thing in immigration. It's interesting, though, and I've compared it. It's a good segue into the Munoz decision that came out, about a week before Chevron, I think. Yeah. The doctrine of consular non-reviewability. I said this on the podcast. Like, Chevron put a thumb on the scale of the agency when regulations and agency action is challenged. It gave a default to a reasonable interpretation to the agency if the statute was ambiguous. And by the way, the circuit court always was the court that allowed to say whether the statute was ambiguous. It's not like it pulled power from the federal courts in that regard, but it put a thumb on the scale of the agency's interpretation of an ambiguous statute. And the Supreme Court, reading Loper Bright, would say, like, this is an egregious wrong to put a thumb on the scale like that. But Munoz puts an entire hand. Munoz puts an entire body on the scale of agent. Well, let's be clear. Munoz is agency action, the Department of State. And the Supreme Court just said completely non-reviewable. Doctrine of consular non-reviewability is alive and well. Now, I spoke to Eric Lee on my podcast, and I'm going to be pushing it out in like a week or two, and he was the lead attorney on Munoz. He still thinks that there are ways to get around the doctrine of consular non-reviewability, but I'm not sure what they are. And it's disingenuous for Justice Roberts to say all of the rationales he had in Chevron in the Loper Bright decision, but then for him to sign on to the Munoz majority a week before. That is completely it's called the doctrine of consular non-reviewability. That's an agency. There are constitutional rights at play. And, dare I say that the interests of a non-citizen who's lived in this country for 20 years, who's married to a U.S. citizen, and the interest of a U.S. citizen to live with their spouse, dare I say that is equally as important under the Constitution as a couple fishermen who don't want to pay for a regulator to be on their boat, as is the case in Loper Bright. Bad facts make bad law in Loper Bright. Maybe the agency should not have interpreted the statute to require the fishermen to pay for the regulators on their boat, but that doesn't mean that the entire Chevron doctrine must be killed. And it does bother me that the fishermen are seen, but Miss Munoz and her husband are not. And Justice Barrett gets around this in Munoz by saying, whether the doctrine of consular non-reviewability doesn't apply to a U.S. citizen. That's Miss Munoz, not Luis, who's outside the United States. Mm-hmm. But Miss Munoz doesn't have a right that she can assert. And it would appear, and I'm not even sure, but it would appear that you don't get due process unless you have an underlying constitutional right. I'm not sure that is necessarily correct, but that is certainly the framework that Justice Barrett and the majority used in Munoz. And now the right to marriage is still a right in this country. Yeah. It's a constitutional right, but Justice Barrett didn't see that as the right that Ms. Munoz was trying to.
Yeah, that was the part that really put it off, because it was kind of con law 101, the parts that I did see on stuff, and that whole scale of what it is, of what rights are, what interests they have, and that's ridiculous for a U.S. citizen not to be her spouse. Getting married is one of the fundamental stuff.
And she was in her defense, she was clear, and she said, this is not about the right to. This is how she gets around it. She said, this is not about the right to marry. This is about to live with one's spouse in the country that they want to live in, and that's separate and not protected by the Constitution. And maybe so, if so framed, but that is not what apparently Eric Lee was asserting, and I'm not sure it's necessary. Eric, I just talked to him earlier this week, so last week, it was top of mind for me. Mm-hmm. And he's been in this for 10 years. He did a great job litigating it with his whole team of people. Ayla and all the immigration attorneys came to support in Munoz. So many amicuses, but the underlying, this is Eric, and it's a giveaway from the episode that I'm going to publish in a bit, but the underlying case, Mendel, they get around it, or at least it's a plurality. I've never actually read Mendel. Apparently it's a plurality decision, but I think, I think at the end of Mendel, they say the consulate gave a facially bona fide reason, so that's good. But they had standing, they had a right, and it would appear, based on talking to Eric, that the right was, Mendel is some sort of alleged communist or something, and he was a professor, and U.S. professors wanted him to come to America to speak in front of some symposium. And so those U.S. professors' First Amendment right to hear this guy speak was a right that then got them into federal court to challenge the denial of his visa. It would appear. I haven't read Mendel.
Yeah.
If that's the case, and all that has to happen, right, is an immigration professor needs to invite Luis to the United States to speak in front of their class about immigration law. I don't know. It does, assuming that was a valid constitutional right, that is these U.S. professors and their First Amendment right to hear someone speak, it rubs me the wrong way that we're not going to say the same thing about spouses living together.
It kind of could be a 601 waiver. Say, well, what if the U.S. citizen spouse can't go to the other country because they can't practice religion in that country or something like that?
Miss Munoz, Eric Lee told me. Miss Munoz is first of all, she's a U.S. citizen. Second, she is a civil rights attorney.
Oh,
She has
wow.
her own practice. She can't go practice law in El Salvador.
Yeah.
And, no one is saying, although Justice Barrett, she brings up the slippery slope. Nobody is saying that you can't have a constitutional right subject to reasonable, weighing and balancing stuff. I mean, we
Yeah.
do that with constitutional rights all the time. For 40 or 50 years, we were doing that with abortion all the time when that was still a constitutional right. It's something that some of the justices don't want to do with guns, but we are still doing it with guns. If someone committed criminal activity, for example, or they were inadmissible, that would trump whatever right. I mean, it can be subject to limitations, but
Yeah.
that assumes the framework is correct and that Ms. Munoz needs to tether it to some constitutional right. But that is the Munoz decision. And a bit bittersweet. Luis would have benefited from this new Biden parole thing. You would never have had to leave in the first place if that had happened. He leaves with a 601A waiver. That's what happens.
Hmm.
Eric told me that, and I'm getting on my high horse now, and I apologize. I'm not usually like this, but it's been a rough Supreme Court season. Eric told me what the tattoos were. He had Our Lady of Guadalupe. He had some dice. He had some like masks, like the two, I don't know, theater masks next to each other. And he had a tattoo of Sigmund Freud. Those were the tattoos. And they didn't even tell him that it was the tattoos until much later. But those were the tattoos that somehow got someone in the consulate in El Salvador to say, you're MS-13.
I mean, when it comes to practice, though, we have in our initial questionnaire if you have any tattoos. I remember years ago, this was Salvador's common problem. So you ask our clients, and it just has a preventative on the practice end. And it's like, I hate sending people out for waivers, even if they have a approved 601A. It's going to be country specific where I feel comfortable sending out at this point. Because when I was seeing what they're doing in South America, they go even in Mexico, or they'll go say they'll do their panel physician, and they'll say, "Oh, you're an alcoholic. Come back in a year from now." That voids the waiver. You got to wait another 4 or 5 years to get a 601 waiver. And it's like, dude, don't even bother at this point. So it's like hard to even guide people to do that, especially with this kind of nonsense happening.
Well, what do you, I mean, and this is poaching from Eric. What do you, because he's been in this for 10 years. What do you do with that? I mean, getting a tattoo is protected speech. That's a First Amendment right too, right? These are the Supreme Court made up the doctrine of consular non-reviewability, just like they made up Chevron deference.
Yeah.
There is nothing that stops the Supreme Court from saying this is too much power with the agency. And, I don't know, Luis. I take Eric Lee at his word that like the guy isn't MS-13 affiliated and this is an entire mistake. But like, even if he is, mistakes happen. Even if a mistake didn't happen in this case, and I have no reason to believe it didn't. But how to bar somebody for life from living with their spouse without even giving them a reason, and therefore without even allowing them to combat that because of a couple of tattoos. What is the difference between street life tattoos and MS-13 tattoos? I don't know the answer.
No,
I mean, if this was
nowadays
a mistake,
everyone's got tattoos.
it's a horrible mistake that will separate these two forever. It does seem like a little more should be due under such circumstances.
It just shows like the role of the consular officer is a heavy role.
Heavy role.
It's just, I mean, they shove 100 cases in front of a consular officer a day to do all these B2 tourist visas, thinking like each individual that wants a tourist visa, that's one loved one they want to see. That's potential never seen in their lives. A sick relative you want to visit, a spouse. This is like an extremely important role that gets like, essentially it's like okay, just do that on the side kind of thing. It's incredible that we treat foreign nationals like this in the visa process.
If I was a consulate officer, I would want the review. I mean, can you imagine being a consulate officer and you deny this case and you were wrong? I don't know how that would weigh on you for the rest of your life. You were responsible for separating a family by mistake. I mean, I would want to be able to get evidence from a lawyer, assuming it's well done and put together, and it's not just, a document dump and it's not just stupid arguments, but I would want to have myself second guessed, at least when it comes to immigrant visas and people who've lived in America previously and have already been given a waiver, you want to be checked, because it's not about getting done with your cases, it's about getting to the most correct result.
Yeah, that process. I mean, they charge a bunch of fees for the too, so they should take that money and sit down and talk. I just, I was talking with Carl Reich, who used to run the USCIS office in the Philippines, and his job was to kind of help them figure out the consulate, figure out what's going on and everything. But they cleaned those systems up. They got rid of that for the most part during Trump administration. And we bring a lot of consular officers on the show. They're always sympathetic and like, because before I started interviewing consular officers, I'm like, dude, these people are horrible. Like, they're just denying these cases willy nilly. But I'm like, oh, it's a mixed bag. And a lot of them want to do good work, they just can't for many reasons. But it's a very deadly. It's a hardcore position, and it needs much more attention, much more education. But it's just they do these consular tours. They just okay, go and do some visa interviews and come back like it's nothing. But it's like literally, it's like doing surgery on somebody. Like, come on, man. You have some
I will never assume ill of the government. I mean, I started my career in the government for 3 years. Eric was talking. Apparently, there is some consulate officer who's been posting pro-Nazi stuff. Apparently, Chuck Grassley was talking about him. So, other than the Nazi officer, I'm not going to be assuming bad things.
My assumption is that like they didn't go to do this to do visa work, and that's like a thing they have to do on the back end, which is a lot of work and a lot of people they talk to. And also, we do consultations with people. We know like you're getting the mix of people. I weed out a lot of people meet with me, so it's much more palatable. But if you're dealing with 150 people a day or 100 to 120, and for B2s, let's say I'm not immigrant, this is not that much, but like you kind of burn out. And I know that people go there, they're crying, or there's somebody's have attitude, they're yelling at you sometimes. Hey, dude, it's like it's very difficult to be with the face of the public like that. There's language issues. It's a very stressful position to be in. And I kind
get
of
that. And even more reason to make sure that there is a process for review and to make sure mistakes don't happen, especially with the immigrant visas. I mean, a tourist visa, do you really know if someone's going to overstay? Probably not.
Yeah.
But I mean, when immigrant visas are on the line, someone's entire life, especially with the people whose lives are already in America, it seems a bit wild. If I was a consulate officer, I would be uncomfortable with this monarch-like power that I have. Everyone makes mistakes.
Dude, I had one guy that came to me. It was at AILA conference. He called me, and then he disappeared 5 years later. Came back, and we finished the case up for him. But he did a case, and long story short, consular officer thought he was married when he wasn't. So they said, "Oh, you got your green card incorrectly because you should have been an unmarried child case." And so I sent him back to USCIS. USCIS misunderstood the case. So he went to court. Removal takes 2-3 years to get a hold of somebody. 3-4 years, this guy's pending before they finally realized, oh, it was error, and they send the case back to the MVC. This guy's child just grows up 4 years, not seeing her dad, and relationships shot like a teenage girl doesn't see her dad. Would imagine what's going to happen. So, and it's like consular officers didn't bother studying like what the laws are regarding marriage in that country. That wasn't a real marriage. It was just like they're living together because they had a kid, but they intentionally didn't get married because of it. So it's just like, dude, like, and I mean, if you had a lawyer, maybe I would have contacted them quickly and try to guide them. And sometimes that works when we do that, but it's maddening.
But if they know they can't be sued, what is the incentive besides assuming that they're good people? And most of them are. But still, the reason we have lawyers in America is because is to guard against abuses in the system. There's a recognition in America that there are abuses and mistakes in the system, and that lawyers are the things that help keep that in check. I don't know if it works or not, but that is otherwise we would just have adjudicators, right? In all contexts, and there wouldn't be any lawyers because the point of the adjudicator is just to get to the truth.
Abuse like it's complicated stuff sometimes, hard to understand, and you have to study the foreign affairs manual. Like it's like, I don't have time for that. It's hard to understand like L1s, E2s, like what's going on here. So that's all a mess. Let's go to the happy one. What was the happy case?
Well, we still have Campos Chavez. I'll get over that quick. I mean, the party's over on deficient notices to appear.
Oh yeah. Well, we've been talking about 2 years. That one, yeah.
On deficient NTAs, long story short, if the NTA was deficient and you were ordered removed in absentia, you can't get it reopened just because the NTA was deficient. It's pretty much the old framework that existed before Pereira and Chavez and this whole thing. You got to show that you didn't receive the notice, or you shouldn't be charged with receiving the notice of the hearing where you were ordered removed in absentia. So it's the old framework. Notwithstanding, in my opinion, and the opinion of the 4 justice dissent, the plain text of the reopening statute, which included Justice Gorsuch. It's not just always the progressives on these issues. And, I mean, Justice Alito, he had me a bit until he started talking about the word change, which is in 239A, I believe. I mean, that change doesn't presuppose that there was an original hearing date. I mean, I don't know how you can change something that was never set in the first place.
Yeah.
I
didn't read the decision. How much into the decision was it that the practical consequences of the decision, was that really it, you think, for the conservative? Like,
come on, that's everything and nothing. They never talk about that.
Is there a Biden decision
how about
about
this?
that?
So Justice Alito was the only justice in dissent in Pereira. It was an 8-1 decision, or 7-1. I'm not sure if a justice had to recuse, but he was the only justice in dissent. And in Pereira, which starts this whole deficient NDA thing, the court said, let me get the quote.
Sure.
Paragraph, this is of 239A. This is what they're talking about. And subparagraph 2 is the notice of hearing. Mm-hmm. Paragraph 2, the notice of hearing statute, presumes that the government has already served an NTA that specified a time and place, because otherwise there would be no time or place to change or postpone.
Yeah.
That is a quote from Pereira. That Justice, Alito was the sole justice in dissent, and, his day has come. I guess this was too far. What's happening? Who knows in the background that convinced the other justices to kind of contort the text a bit and get to this result. Maybe they didn't want to open the floodgates. But four or five circuit courts had already held that the plain text means the opposite. The Fifth Circuit was all over the place a bit. The 11th Circuit, it was kind of weird. No court had really said that the plain text allows a notice of hearing to clean it up. But Justice Alito did. I mean, I find it very hard to believe that, 18, 22 appeals court judges couldn't read this text? They were so wrong with this text. It is surprising. Not to mention the 4-justice minority in this case. So it is too bad, but let's be real. It was always a technicality argument. Some of them. Some people don't. There was an 11th Circuit case the same week as Campos Chavez where the woman didn't show up because she literally didn't know what the address was going to be where she was living at, and it seems like her boyfriend got it wrong over the phone, and so she never received the notice of hearing. But if the date and time was in the NTA, maybe she shows up because it's in the NTA that was hand delivered to her when she was apprehended. I mean, there is a reason for the date and time being in it, which is all the things Justice Gorsuch says in his Chavez. But anyway, it was a bit of a technicality argument all along.
It just kind of goes why are they not putting time and dates? It's because they're so backed up in the court, and they tried the system where ICE could go in and fill up, but that didn't work out. So it just the immigration system is completely broken.
We're starting in 97 here. I don't think we can say the same now as back then, but now there is a system. ICE has that. So it's two different agencies. That's the problem. As you know, ICE are the prosecutors and EOIR, DOJ, is the judges. So it is kind of weird to have a prosecuting agency set the hearing before the judge, right? I mean, that is a little weird, but that is what the statute says.
That's immigration law. It is super weird.
Now ICE, as I understand it, has access to the court's docket and the ability to set whatever hearings they want for those initial hearings. But what do you think they have in 98? You know what I mean? In 98, they didn't have anything, especially a border officer in Harlingen. That's why. But Congress wrote the statute, and the Supreme Court really seems to care about what Congress wrote in their statute, except when they don't. Yeah. I don't want to be cynical, but come on, guys.
At the end of the day, government is, or whoever has it, and power makes power. Is just this. It is what it is. It seems the hope was America would be different, governed by laws and all that kind of stuff. And to a certain extent, it is. But you know, it is what it is, unfortunately.
I'm not turning on America yet. It's been a rough Supreme Court term, though. I mean, if you're gonna be textualist, be textualist. If you're gonna be originalist and care about
Yeah,
stare decisis, do it. But you don't make the mismatch of
is that
all the
cognitive
things.
dissonance, having two different thoughts at the same time? And is that what the example of it is? I'm not sure, but yeah, stick with one thing. If you especially because the justices are textualists, which actually I'm kind of a textual myself, but it's like stick with one thing so we know what's going on. But
It seems that textualism must mean more than one thing. I mean, in all of her dissents, textualism, originalism, they do seem to be ways of getting to the result that wants to be gotten to. There are some outliers, but like Justice Jackson, many of her dissents, and Kagan recently, but like many of Justice Jackson's dissents in her short time on the bench have been like, I'm the textualist.
Yeah.
I'm the originalist, except I am looking at the amendments in, 1865 and the 13th, 14th, 15th amendments. I'm the textualist. Here's what's the plain text mean. You guys are going against the plain text. So if both the majority and the dissent is based on the plain text, the plain text doesn't mean anything.
Yeah. Well, I've been reading like the Torah and the Bible a lot recently, and it's 3,000 years of this, and people for 3,000 years have had the opposite conclusions on the text the whole time. So it's like, it is meaningless. I'm saying
What's your having read the Old Testament? What is your opinion on having multiple wives, John? It's allowed, right?
Yeah, it's allowed. It's not. I mean, I think our society is probably going that direction. The way
it's not recommended, but textually.
Yeah, I mean, once I met my wife, I'm like, that's gonna be impossible to have more than one wife. So I don't know how that works out with those people, but yeah, but it's the whole every sentence. There's two different interpretations, like complete opposite interpretations. So it's like,
yeah,
yes, this human beings. It is what
well,
it is.
in all due respect to God, I don't think the Bible was written to be a strict governing entity. I mean, it's guidance. I mean, it's not a statute. The Bible's many things. It's not a statute.
Yeah.
Whereby, I mean, the Ten Commandments, maybe that's an exception. Those
yeah,
are
I was
pretty
gonna say the lawgiver. Yeah.
But like, whatever.
People can make it what they want. Just want to speak your heart. Yeah. Yeah. No, I hear you. I hear you. Well, I'd love to talk more about that kind of stuff, but I have another podcast I got to do it 5 minutes ago.
I didn't even get to the good one.
That's what I'm saying. It's all good. I'll delay the pod. It's a live show, but if people will wait, I guess.
I'll be really quick. Don't sleep on Black and Decker which is a fun Black v. Decker, not Black and Decker. Black v. Decker out of the Second Circuit on May 31st, which held.
Who would have thought the court case Black v.
Right.
Names that pop up, it's just unbelievable.
Right. Which held essentially that people subject to mandatory detention 236C, they likely have a right to a bond hearing where the government has the burden after they've been detained for 6 months. This is the last question left open on the Jennings decision that was remanded to the 9th, and it's just floating, I think, at the district court level. But the Second Circuit has stepped into this vacuum and held, yes, it is unconstitutional to indefinitely detain people.
Hallelujah.
That's what the Supreme Court left open in Jennings, and they are entitled to bond hearings. So if this isn't the first, it's the second. I think it's the first. The Third Circuit has kind of flirted with it, or maybe they even ruled on it, applying, by the way, the Matthews test for due process to determine in an individual case whether or not due process requires a bond hearing. So it's a big deal for non-citizens detained in the Second Circuit. This will go to the Supreme Court soon, and we will close the chapter on prolonged detention that's been going on for 24 years now, and hopefully it's not.
It's a disgusting thing, but yeah, it doesn't look good based on track record right now, Supreme Court. But it's disgusting these indefinite detentions through ICE.
How about this quote? You say this guy. I mean, this is a quote. I posted this too. So before Jennings, a lot of these cases were popping up in the circuits where they were saying the statute, or as a matter of constitutional avoidance, we read the statute as requiring a bond hearing after 6 months and flipping the burden. So in all of these circuits, including the 11th Circuit, you could get these bond hearings after like 6 months. And then I'll let you go in a sec, but it's important. But so we have this information. We have years in these circuits now where people like this were getting bond hearings, and then it stopped. And the quote is this: before Jennings vacated our precedent in 2018, data showed that 62% of 236C detainees given bond hearings were released, confirming the absence in many cases of a sound justification for detention. Similar statistics out of the First Circuit, by the way, and probably all the circuits, restated if actually given a bond hearing before a neutral arbitrator immigration judge, a lot of these mandatory detention people were found not to be dangerous and not to be such bad flight risks that an amount of money or an ankle bracelet wouldn't suffice. We were detaining in the Second Circuit 62% more people indefinitely at like $200 a day. Not that that's the worst part of it.
Yeah. But there's financial interest involved here too. I mean, there's
for no justification for taking away someone's liberty when they're not a danger and not a flight risk. 62% error without bond hearings from 2018 until this decision was issued a month ago, and that is very scary to me. But now the decision has been.
It's beyond words what these people have. Good. Yeah, hopefully. I mean, this one gets fixed up. It sucks that it has to go through this long, and these many people have to go through it to get a proper decision, some justice on this. But it's just crazy. But thank you as always for coming in and explaining this stuff and reading it for us. I would never know about any of this stuff other than what I see on the news, which is going to be unreliable. So this is probably the best source of this. I mean, best source is going to Immigration Review. I was going to say podcast review. It's not podcast review. Immigration Review podcast. You get the full details of this. You found wherever podcasts are sold. And so definitely check it out. Kevin A. Gregg, our good friend.
I appreciate you saying that, Jed. A lot of smart people with Ayla and Outside are also talking about these cases. And, how are we going to get around them? How are we going to distinguish them? That's a whole team effort. So appreciate you having me on and letting me get on a soapbox. I don't usually do that, but I guess I found myself doing it today. So, it's a good thing the Supreme Court term is finally over for 2024, because I don't know how many more weeks I could take.
For sure. Well, I appreciate you coming on the show again. We'll see you again next month. I wish I had more time, Russell, behind the scenes. I was going to talk a little bit, brother, but hopefully we could regroup and chat a little bit before our next podcast. I want to just get to know what's going on with you some more. But thanks for coming on, and I'll see you next month, I guess.
See you.
All right, bro. See you soon. Bye.